Will I have to pay my spouse's loans if we divorce? Patricia Van Haren, family law attorney. The general rule is that all debts are community property. However, if there's an asset that's acquired with that debt, that asset would also be community property. The community property assumption applies to all property that's acquired by a married person during the marriage, including loan proceeds. This would apply to secured loans, unsecured loans, and personal loans that are incurred during the marriage. However, they may have exceptions to this rule. For example, if a loan is obtained only in the name of one of the spouses and it's secured against a separate property asset, to improve that asset, then the spouse may be able to argue the asset continues to be separate property, and the loan would be separate property as well. Evidence must be presented to show that in making the loan, the lender intended to rely on the value of that asset rather than the creditworthiness of the spouse. When a loan is unsecured, there's a reasonable assumption that the creditor relied on the creditworthiness of one of the spouses, and creditworthiness or the ability to pay a loan is determined to be a community asset. If a loan was obtained for business expenses, then the loan would be a community debt, just as the business is a community asset. If a loan is used for gambling debts or to support a substance abuse addiction, and evidence is presented to show that those funds were used for illegal activities, then the other spouse would not be responsible for that debt. Other loans that may be questionable are personal loans from family members, which have no promissory note attached, and there have been no payments made. Arguments may be made that these are not actually loans, but a gift to the community. Our client's spouse claimed numerous personal loans in a dissolution case. None of these loans were ever mentioned to our client. The client was not aware of these debts, and there were no promissory notes attached. The funds didn't go towards any community property expenses, and the spouse was making claims that property purchased by those loans was a separate property, but wanted the benefit of the community paying the loan. We were able to have all these alleged loans excluded from the division of property. If you have any questions about loans in your case, or you want information about how loans are handled in a divorce, just shoot us over an email or give us a call.